transpired was this review petition. While there were all parties, it covers and will have an impact on about 12 lakh teachers who were in service at the time that the RT Act section was amended.
So we have read that that special 18 months code was for protecting the teachers who are already in service. And it can't be made applicable for future employment. That's what we.
The idea was simply this, that in curriculum and in everything else, the program is exactly the same, including the intervention. It's a 24-month program.
Oh, it's 18 months.
The program that has to be followed, as has been laid down by NCTE, is a 24-month program. Now, the relaxation that was provided to ensure that they fall within the timeline because Section 27 was amended and the proviso was included, which allowed those in service to complete by 31st March 2019, which required it to be completed in less than 24 months. So that's why the relaxation was brought in, so that they will finish in 18 months. Now, what has happened is this, that 18-month period is being treated as equivalent not by the Uttarakhand High Court. Your Lordship judgment says that the High Court couldn't have gone in and created an equivalence. That perhaps not what I think would be borne out from the record, because there were actually an expert committee that had been set up by NCTE. All this took place on directions which were directed by the central government by exercising its powers under Section 29. There were advertisements which were issued with the Prime Minister's photo on it, saying that please ensure that you will complete this by 31st March 19. The idea was that once, as an in-service teacher, I get the qualification of 18 months, it is exactly the same as anybody else getting a 24-month qualification. Now, the effect, of your Lordship's judgment is that in schools, for example, which have gone through the plight of COVID, who had to close down, etc., those teachers, when they step out and they apply, they are told that, sorry, this is not being treated as equivalent to the 24-month. That is the problem. It is, in fact, I just wanted to show you Lordship 3-4 documents which will show what the background is. What took place is, and all this took place over a short period in the middle of 2016. The first thing that took place is that the MHRD issued a letter to all the secretaries. MHRD said, look, we have found that there are in-service teachers and we must take care of them. So MHRD tells the secretaries that Nios will be the institute, and through that we will have this course. The idea throughout that there has been no specific different stand that has been taken either by MHRD or by Nios or by NCTE or by any of the universities or any of the state governments, that the 18-month program was to ensure that those in-service teachers will get the same qualification, that those otherwise would have the benefit of getting over 24 months. The others would take 24 months over it languidly because they were not in service. Those in service, if they have to take a full day 24-month course, they can't also be teaching at the same time. That's the practical difficulty. So what the MHRD did is, this was on 3rd August 2017. Barely 6 days later, the amendment that they suggested gets the approval of the President. The amendment that made to the section. Which is why on 21st August 17, all this is taking place in the same month, in August 2017. On 21st... Sorry, I'll just take a look. I'll just give you the dates with the pages. Just to 21st August 2017, the same month. MHRD writes to NCTE under Section 29 of the NCTE Act, directing the following relaxations. If for a minute, I can just read out Section 29 of the Act, because that is relevant. That's where all of this starts. NCTE. नहीं NCT नेशनल वो शायद इसके अंदर होगा NCT no NCT I just handled it. I'm sorry, one copy that mine. Section 29 of your lordship says. It gives the central government the power of relaxation. So this is taken at the highest level. It's not that the High Court of the Imperial Judgment decided equivalence. The relaxations that were directed in exercise of this power by
The council shall in the discharge of its functions and duties.
Yes.
Under this Act, be bound by such directions on questions of policy as the central government may give guidance to it from time to time.
Correct.
The central government has to hear a question. Is one of policy or not shall be final.
Fine. Correct. So on policy decisions, therefore, Section 29 gives the central government's power to give those directions, and the NCT doesn't have the option of saying, no, this is not binding on me, NCT has to follow suit. Now this takes place on 21st August 2017. Now we have a convenience comparison given your lordship, which shows what they've done under the Section 29, same month, which is at page 53. Second convenience comparison. Page 53. Second one.
Yes.
This is your lordship, page 53. This is regarding training of untrained in-service elementary teachers in these schools. An amendment to Section 23 to extend the period for such training to 31st March 19 has been passed by Parliament. Your lordship,
Where are you reading? Page 53.
page 53. The first paragraph. This is 21st August 17 letter from your lordship. Yes.
This is regarding training.
Yes, regarding training of untrained in-service elementary teachers in government schools, etc. An amendment to Section 23 to extend the period for such training to 31st March has been passed by Parliament. Please note the date is 21st August 17. So therefore 2 years are not available now. It's only till 31st March. Teachers at elementary level is 11 lakh. That include teachers working in government, government-aided and private unaided schools. However, the actual number may change. NIOS will be completing all academic activities related to above training by 31st March 2019. This is for the same DLA.
This 18 years diploma is equivalent to 24 months, and therefore they could apply for the assistant teachers post available in the state of Uttarakhand.
But your lordship have reversed that part of equivalence, saying that the court could not have deemed equivalence. These two posts are not equivalent. Is originally what the problem is. Let's clarify. If I'm in service, if I'm in that one school for the rest of my life, your lordship, this, that school now, using your lordship's judgment, will say, no, you don't have the 24-month DLA qualification which is required, because the Supreme Court has reversed the Uttarakhand High Court's finding of equivalence. Because the lordship reversed the finding of equivalence, my 18-month DLA course is treated as some special requirement for me to remain state
Services.
only in this school. But I can't move from one school to another because it's not being treated as a DLA 2-year qualification, which is what is required by the NCT. Now, apart from the Interim judgment, there are 5 other high courts which have given the exact same judgment of equivalence. 2 of those your lordships consider, which is Patna.
But we are in Uttarakhand.
Yeah, you dealt with Uttarakhand, but at para 32 of your lordship's judgment, you have said Patna and Tripura were therefore wrong. So the effect today was that there are other
I think Tripura was Justice Qureshi judgment.
Yes, it was just Qureshi. Now, the problem is twofold. One is of movement. If I, as a teacher, want to move to any other school, I now have a hurdle where I am being told your 18-month DLA is not to be treated as a 2-year DLA. Why? Because the NCT regulations have overarching regulations. Those regulations say your qualification under Appendix 9 and 11 of those regulations are that you need a 2-year DLN. That's what you need. So this is not technically a 2-year DLN. So the schools which say no to me may not technically be wrong. They may not be wrong in saying, look, the requirement is 2-year DLN, you don't have 2-year DLN. Supreme Court has said 18-month DLN is not the same as 2-year DLN. That's my hurdle. That's hurdle number one. Second is, if I belong to the unfortunate view that the schools are closed for one reason or other, it could be COVID, it could be any one or other reason, then I'm left with nowhere to go. Otherwise, your lordships will protect me to that limited extent. And the third thing is most important. There were 2 SLPs which came before your lordships. One was by the state, I don't know how they are agreed exactly. And the second...
We recollect Mr. Sethi vehemently argued on behalf of the state of Florida.
So he relied heavily on the state's rules. Now the state's rules had in fact subsequently been amended. And the state's rules said, as an alternative, anything that may be prescribed.
The question before the Uttarakhand High Court was that whether such persons who were having 18 months diploma could be permitted to compete for the post of assistant teacher which are advertised.
Who are in service?
No.
It's only in service for us.
In service.
All of us are in service.
In service.
No, he's just talking about the High Court.
मॉर्टीन 2-in-1 इंडिया का पहला स्प्रे जो है मच्छर और कॉकरोच दोनों पे 100% असरदार।
As teachers who are already in service on the date of this notification is concerned, there can be no dispute that for them it will be qualification requisite qualification equivalent to 2 years diploma. But not for the persons who are not in service on this book. That is what we have heard. The government will be suspended.
What he wants that this qualification should be held good as 2-year diploma course for all time to come for him. That is what he wants.
But the admission is the basic requirement.
The school one is there. For a reason, closure and no student. Then, though he was in service on the date of that notification.
That's it. That's only it.
Then that's only the recruitment. This batch of person.
Any other recruitment provided on the date of that notification, you are already in service.
That's it.
In his service, if he attempts to switch over to some other service,
Then
he will claim benefit saying that I am in service. Even today I am in service.
I know, on the date of notification.
On the date of notice.
On the
Any other notification.
no. On 22nd November, 22nd September. No, where is the 22nd September?
No, but we were dealing with only one notification.
So all that notification.
See, where is the problem? If you have any problem in future vacancy, future recruitment, then you come. You are just thinking of a hypothetical situation that in future it may not endure to your benefit. Therefore, it should be reviewed.
As a consequence of your
इसमें page 76 में तो some no. Where is that order dated 22nd of September 2017?
Says whereas the said authority proposal has been considered by an expert committee constituted by the committee considered the found that the NIOS had ability to prepare conduct the program And the legislation proposal meets the requirement of DL or DL program of NCT. They're giving the approval to an 18-month program saying that it meets the requirement of 24 months. And therefore granted recognition at the end at page 65 to NIOS to have that program. This is why if you move over to page 76, page 76, the page 76. We say that all the request, I'm sorry, rather than justice, have page 76. On the request many untrained service teachers who could not apply earlier, final extension is being given for registration for diploma in elementary education (DLM). This course is approved by the NCTE and MHRD. Anyone with this qualification can apply for job anywhere in India. They say this is the last opportunity for such untrained in-service teacher.
What training of in-service untrained teachers?
Untrained because we don't have the DLM. But Malhotra page 76, sir.
No, 64.
Oh, 60. So sorry. 64, yes. So, one thing your lordship can take it, all of us are in service, we were untrained, we took the course, the government has made 1,100 crores from 12 lakhs of us who applied, who took this course, we completed it on 31st March 2019. There's nobody else, there's no other possible kind of candidate who is before your lordship. That's point one. Point two, in those two SLPs that came before your lordship, I think your lordships were under the impression that those who had come were also DLN candidates. They were not. They were not 24 month DLN candidates who had a problem with 18 month DLN candidates. They were BEd candidates. BEd candidates, which is a qualification.
No, Prime Minister, that is a certain law. BEd is not a qualification for primary teachers.
Come to this court and disturb the High Court's judgment, is what I'm saying. They absolutely had no locus. But they misled your lordships because we took the SLP out, we filed that also. In the SLP, in the synopsis, they say we are DLN candidates. But then we find that the three petitioners were all three were BEd candidates, so they didn't have the qualification, they could never have challenged this. It was not 24 month DLN coming against 18 month DLN at all. So they have no problem. 24 month, 18 month, we're all the same DLN. We happen to be in service. So this is...
No, but those persons from Uttarakhand who had approached the Uttarakhand High Court wanted to compete in the in pursuance to the advertisement for recruitment initiated by Uttarakhand.
Because we believe that our DLN 18 months was equivalent to the DLN 24 months. We had no reason to believe otherwise. And the High Court, even the High Court, I must tell you, lordships, did not have the benefit of the document I'm showing you, which is section 29 directions by the MHRD, the expert committee's minutes. The expertise was not of the High Court. The expertise was at a policy level of the central government. The central government says that look, this concession should be given. They're all full-time teachers. Therefore, they won't be able to do 24 months by 18.
What is your problem now?
Our problem is only this. If we are not treated as equivalent,
Who is not treating you?
All the government, one is page 687 of that last compilation. The one open there, page 687.
You are still in job in Uttarakhand.
Yes. Most of us are those, now I will not speak very briefly. Among the petitioners before your lordship, there are a few who are in service in a particular school who want to move. There are others whose schools are closed and who are without a job. So there are both categories before your lordship, but all of them are in service teachers who finished the 18-month course by the 31st of March 2019. There is no other category here. And I am saying it with some responsibility. I think Mr.
In 301.4, all 94 petitioners are not appointed by the board in the state.
That supports what I'm saying.
They are not appointed at any stage. They are claiming to be in appointment in some management.
So they were not in service at all.
submitting the examination. So this. They are ready to put it in affidavit. That they have pleaded something completely contrary to what is actually there. No, they have taken the course afterwards as appendix 9 course in the regulation. Insane. It's appendix 9 course.
In fairness, we are limiting it only to those who have taken the NIOS by 31st March 2019. We're not dealing with anybody else. If Mr. Chatterjee is right, then those people will not get it.
In fact,
Let's stand by our statement.
2010, the training was not a qualification.
Let's.
I want to pursue this. In different matters, different states.
There have to be those original practitioners for those states. Yeah, state.
The state.
No, in your matter, who is your opponent? Which is your opponent?
State.
Which state?
Uttarakhand, man.
Uttarakhand.
Uttarakhand also has different strategy. Because I have the report. That's virtual tactics and order. This is everything on the finger of Interim. Same matter, no? It's like
Doesn't that matter? He can come in and whatever they decide. That was fine. This is not as we take it also 24.
We will have to hear the states.
Very good.
Unless we stand by our statement, all of we were in service candidates.
We only consider only such persons who were already in employment on 22nd of September 2017.
yes, correct. In fact, that's what happened in 2010 when the Rapid Act came. There was no teaching qualification required at that time. So, the government gave a 5-year window for getting the training done in 2015. When this was not completed in 2015, it was extended in 2017 and then extended.
We have traced the entire history in our judgment. It was a special provision to meet that deadline.
For the requirement of having third party. And the state, when people back to 2017, they are not showing anything in government.
We are not going, even if we allow or clarify the order, we are not going to consider individual cases. We will only say that such of the teachers who were in employment on that date to be considered as in having the necessary qualifications.
Proviso
Under the state statute, if they were in employment at a particular date, we will not have.
Section 23, just 1 minute, 1 minute, 23(2). I'm agreeing with Mr. Chagrin.
Don't have a data. If you are their services are not removed, they are out of the group.
That's correct. So let's just to help them.
How can they claim that? No, but then NEOS was permitted to conduct that examination only for in-service candidates.
Yes.
And the Nios could not have considered the examination for anybody else. No.
Now they don't have it on. They couldn't.
Exactly.
What is he saying?
Who were in employment? If the Nios has permitted those candidates to appear, it is presumed that they will be already in employment.
Well, in fact, section 23(2) provides.
But one thing is clear.
Yes.
We will be putting up a deadline of 22nd September 2017.
Yes.
Who were in employment on that day.
No, that's what I wanted to tell you, Lordship. The section requires, and I'm making it against myself, I need to be fair. Section 23(2) proviso of the Act says provided further that every teacher appointed or in position as on 31st March 2015, 2015, that's the cutoff date, 31st March 2015, who does not possess minimum.
So then we will put in only such person who were in employment at that time.
Absolutely, that's correct. That's correct. 23.
So वो बाकी सब एमएस में अगर भी नोटिस देना, नोटिस देने for 4 weeks. That's what we are saying.
In all areas also make
No further hearing. We will only be clarifying this position.
Absolutely.
That has been misinterpreted because I don't think that.
So just, I mean, if there won't be any further hearing, let me show you one page 686, which I'm showing you in that file volume. It's a notice by the government of Assam, which refers to your lordship's judgment and says, the advertisements are prepared and published in compliance with the order dated so and so, and I say the assembly so and so, where it is stated that the qualification of 18 months DLN acquired from Nios is no longer a valid qualification to be eligible for fresh recruitment to the post of teachers. This is with the just correct.
They will be entitled only if they were in service on 15th of
31st March 2015.
So you issue notice in all the MS. Renewable, when can they be served?
We have served. Notice has gone, just one. Notice has gone in all 9 MAs already. In the review, we are taking fresh notice from your lordships. If your lordships will give us Dusty, we've served them, but give us Dusty as well. We'll serve them again.
If we remember on 11 December.
11 December is fine.
my lord, standing supporting time to buy our time.
What is your stand? You supported the petitions before the High Court. Now you can't change. So therefore what?
Allah supporting, but arguing also.
So should we keep it in December or January? What is it?
December. This small clarification. I mean, there doesn't seem to be much cabin.
Renewable on 10th of December. We need to solve the state government through standing councils.
Very happy.
तो ये 3:30 बजे